Hello, everyone. Welcome to the lecture podcast for week 3. And in this lecture podcast, we talk about corporate governance and management. In week 1, for example, in the introduction to this unit, we talked about corporate governance as a topic. And we talked about how the failures of many businesses in the past, especially the past few years, has led to a discourse and a debate about the importance of corporate governance, mainly about who becomes responsible when a business fails. Because as we have noticed, especially during the financial crisis, or what some would call the economic crisis around 2008 and lasting towards 2010, many businesses, which were huge corporations, had actually failed. And in the process of these companies failing, it led to the loss of savings and wealth on the part of a lot of people who held shares in companies. And at the same time, it had a cascading effect in the sense that there could have been creditors who were owed money by the company, and they could no longer be failed when the company failed. It could have been customers whose contracts with the company could no longer be serviced. So maybe, if you own a car, if the business fails, you could no longer have your car serviced. There would have been implications on the part of companies, many of who, when the business failed, would have lost their jobs, and some of them would have lost their chances at having some kind of a retirement fund. Would also mean that in many cases, the government would have to step in to either bail out the company or perhaps, help in terms of providing benefits to people who would have lost jobs. And that would have happened in a welfare state such as in Australia, where when people lose jobs, the government steps in and, provides benefits to people who are unemployed. And so therefore, when you speak of the effects of corporate failure, we know that the effects are quite massive. That leads to the question of how could companies fail? And if companies fail, who is responsible for that? And could the law have done something to ensure that corporate failures are reduced or minimized? And in the event that companies do fail, can anyone be held to account? And that brings us to the discussion about what corporate governance is about. And we're going to talk about that. And at the same time, when we talk about corporate governance, we wonder who is responsible, because if you're working for a company, you deal with management and you know that it is the top managers. He might be the chief executive officer, chief operating officer, it could be the senior vice president, and so on. They're actually the ones who are managing the company, and they are the ones who you see to be making the decisions. And they could also be it could be top executives or top management that often are the individuals who you see to be making a lot of money, either even when the business is doing well and even when the business is not doing well, because they provide themselves huge bonuses and incentives. And so we often wonder whether is it management that is legally responsible in the event of a business failure. And when you examine, for example, when you look at the management literature, especially in the 1990s and even before then, the discourse is always about the role of management, but not the role of the board of directors, and that they one and the same. And that is the topic that we will be focusing on tonight, or in this lecture podcast. We seek a distinction between governance and management. And at the same time, we have to bear in mind that when we went through week 2, we talked about the corporate legal entity and the corporate form. And we became aware that there was a legal innovation in about 1870, in the case of Solomon versus Solomon, where the courts, what we know to be now part of the common law, the court said that when a set of owners decide to form a company, what can then happen is that company becomes a legal person of its own. And that legal person is distinct from the natural person, the owners or the individuals who own the company. And that company, therefore, that becomes a legal person is invested with legal personality, with its own legal rights. And it has the right to enter into contracts, the right of perpetual succession, the right to enter into debt, and so on. And it also means that as a result of the idea of the corporate legal personality being distinct from the owners, what it actually means is that the owners, therefore, the shareholders, the people who own shares in the company, these owners or shareholders have only a limited legal liability because they're distinct. What it means is that the debts and liabilities of the companies do not become the debts and liabilities of the shareholders themselves. And that is an important innovation, because legal innovation, because it then means that it is possible, it is less risky for individuals to invest in multiple companies, which they can't really manage. And because they can't really manage it, these various companies that they invest in, they shouldn't have to be held liable if the business fails. And so that is the idea of limited legal liability. And with the notion, or with the understanding, therefore, that ownership of a company then is divorced from the management of a company. They're typically no longer one and the same. So that when you look at big companies, whether it's Microsoft, or it's Qantas, or it could be Commonwealth Bank or ANZ, or Coles or Woolies, you would realize that in terms of the ownership in the company, the ownership is actually quite dispersed. It could be hundreds, if not thousands, of people who own various shares of the company. And the ones managing the company, therefore, are not necessarily the owners. And this has legal repercussions, because you begin then to wonder who wields authority in behalf of the company. Is it the owners, the shareholders? Is it the majority shareholder? Is it the managers who actually make the day-to-day decisions? Or is it the board of directors? And so that leads us to a discussion in this lecture podcast about corporate governance, which involves discussions about directors' duties and responsibilities, and then an attempt as well to try to distinguish between corporate governance and management. So after studying this topic, you should be able to discuss and explain the concepts of governance and management, directors and officers' powers, duties, and responsibilities, and the business judgment rule. So let's begin by talking about management, especially because you're studying an MBA, which means you're trying to become masters of business administration. What you would have learned and focused on is really about management. You would have, if you had the chance to go through the book of Richard Daft on management, you'd know that there are 4 P's of management: planning, organizing, leading, and controlling. And a lot of your MBA program would have focused on various functional areas of management. So some of you would have been, trying to study about human relations or human resources. You could be studying finance or accounting or marketing or business management or leadership and so on. And so therefore, if you notice, the focus of the MBA program and most of discussions in business schools and teaching in business schools has always been about management. And there's really been very little in the nature of a discourse or a discussion about corporate governance. And so therefore, the idea about corporate governance is really of a more recent, is something that's really more recent, in the sense that it's only been in the 1980s that there has been a lot of discussion about corporate governance. And still, we wonder, what is the relationship between corporate governance and management? And in particular, who runs the company? Is it management? And who has the authority in the company? And we can often ask, does management exercise the powers of the company? Or is it the board of directors? And so therefore, ultimately, because when we talk about the failures of corporate governance and therefore the rise of a discussion about the crisis of corporate governance, we're essentially trying to ask the question, who is held accountable when a business fails? So when, for example, the ASIC has to come in, or the Australian Securities and Investment Commission has to come in to investigate misbehavior in a company, or investigates why a business may have failed, the question is, would it attempt to wield its regulatory powers over the top managers, or would it actually try to assert and enforce its regulatory authority over the board of directors? And then we ask why. So what we need to do, therefore, is to understand that governance, as we later on see, lies with the board of directors. And when we speak of management, the actual management of the company, meaning the day-to-day activities, that is done by a top management team, which can typically be the chief executive officer, the chief operating officer. Sometimes you have the chief financial officer, the chief technology officer, could be a senior vice president, and so on. And the top management, or who we sometimes call the officers of the corporation, are the ones who are involved in planning, organizing, leading, and controlling of a company. But at the same time, we will also learn in this lecture podcast, or if you go through the lecture or the study guide, we will also learn that because it is the board of directors who are actually the repository of the legal authority of a company, it is actually the board of directors who wield corporate power. Necessarily, therefore, directors, because they are responsible for setting the strategic direction of a company or the strategic objectives of the company, and they're the ones who make the decisions, the major decisions in behalf of the company. They're actually involved with planning as well. Necessarily, they're involved with organizing, or in the case of some of the management literature, the distinction between organizing and staffing. And the board of directors as well is involved with organizing and staffing because they are responsible for choosing the chief executive officer, and oftentimes they're also responsible for choosing the chief financial officer, who reports directly to the board and not to the chief executive officer, to make sure that the chief executive officer is not in a position to force, for example, the chief financial officer to fudge figures or to play around with the books of the company. And necessarily, therefore, the board of directors is also involved with leading the company. And the leadership of the company can be in the form of ensuring that the director, the top officers of the company, or the officers of the company, follow what has been set in terms of the strategic directions and objectives of the company. And of course, they are ultimately responsible for controlling the company. And when we say controlling, it's essentially ensuring that you make a distinction between what has been set and what your goals are. And if there is a variation, you try to make a control, you make adjustments to make sure that the company continues to move in the direction that has been originally set. So to that extent, therefore, we see that the board of directors undertakes the 4 P's of management: planning, organizing, leading, and controlling. But at the same time, we know that the officers of the company, or the top executives of the company, are themselves undertaking the 4 P's of management of planning, organizing, leading, and controlling. So they have almost the same functions, but the difference is that in terms of ultimate responsibility for management, that responsibility and legal authority lies with the board of directors, and they simply delegate much of the details and the day-to-day operations and the day-to-day operationalization of management in the officers of the company or the top management team. But they're actually both involved with the task of managing the company. And when we look at a way by which corporate governance is defined, corporate governance is often defined as the framework of rules, relationships, systems, and processes within and by which authority is exercised and controlled in corporations, and those who exercise and control authority are held to account, and concerns the manner by which corporations are regulated and managed. So let's just examine that a bit. So corporate governance, therefore, has 3 aspects. One is the exercise and control of authority. You exercise it, you also control authority, but at the same time, those who are exercising and controlling authority have to be held accountable. So when you look at corporate governance in the past, the focus was simply on the exercise and control of authority. And in that case, therefore, there would have been discussions about what's the distinction between company law, which focuses simply on the exercise and control of authority, and how different is corporate governance. And corporate governance, therefore, tries to make an assertion that you don't just talk about the exercise and control of authority, you have to talk about accountability as well of those who are exercising and controlling authority. And then there's that aspect of regulation and management of corporations. Now, we need to remember that when we speak of the word corporations, therefore, especially because we're using the word corporate, there are many types of corporations. The idea of a corporation is very similar to that of a company in the sense that a corporation is a legal entity with a legal personality that is separate and distinct from that of its shareholders. And therefore, a company, at least in Australia, is just an example of a corporation. And because we will recall in week 2 that to be a company, it must be registered with the Australian Securities and Investments Commission. But there are certain corporations or business entities that are corporations but are not, but haven't really been registered with ASIC, in the sense that you do have foreign corporations that operate within Australia, and therefore, because their incorporation hasn't really happened in Australia, and they haven't really been registered in Australia at the very start, they are deemed corporations but not companies. And because they are corporations, it could have been Holden, which I think is an American company, is it? Setting up a plant in Australia, but it is a foreign company. It is a foreign corporation. So in Australia, it is a corporation with a separate and distinct legal personality from its shareholders, but not a company. Because to be a company, it has to be a business entity that is registered and incorporated through the Australian Securities and Investments Commission. So having made that clarification as well, we should then clarify that when we talk about corporate governance, we're actually mainly looking at the board of directors, because it is the board of directors that exercises and controls corporate authority. It is also accountable for the exercise and control of corporate authority, and the board of directors actually manages the corporation. In the sense that when I talked about planning, organizing, leading, and controlling, as I pointed out earlier, the board of directors does undertake the tasks or the processes of planning, organizing, leading, and controlling at a higher level, which it often then delegates to top management in terms of undertaking the day-to-day and the minutiae or the details of the aspects of managing a company or a corporation. Now, because we know that the board of directors wields corporate authority, what we need to do now is to really figure out what exactly are the powers of the directors according to the Corporations Act 2001. And we need to remember that when we speak of corporate power or corporate authority, those powers and authority are not just regulated by statute or the Corporations Act 2001. So when I speak of a statute, it means a law that is, or an enactment that is passed by the Commonwealth Parliament. But we also speak of the law being formulated under what is known as the common law. So in other words, prior to the Corporations Act 2001, or prior to the enactment of a statute, and especially in Australia, because the Australian Commonwealth came about only in 1901, what it means is that the law was already there even prior to the development of the Australian Commonwealth, and part of that law was a result of the common law. And what the common law really means is that it is judges who end up making the laws. In other words, where positive law is absent, meaning where there is no enactment or statute that has been passed by a parliament, and so therefore the law there may be a gap in the law, what then happens is that if there is a matter or a case before a court or before a judge, when the judge makes a decision or makes a ruling or establishes certain legal principles, those rulings or legal principles then become part of the law, and they become part of what is known as the common law, because it is a law that is common among, in a particular legal jurisdiction. So the sources of law, therefore, would be statute or enactments of the parliament, or the common law, meaning laws made by judges. They're laws, they consider laws. They're judge-made laws because whatever the judges say actually become part of the law and are binding in a legal jurisdiction. So, but for now, when we talk about directors' duties, the Corporations Act, therefore, in a sense, only codifies, it has only managed to codify what is long recognized in the common law. And that is that the business of a company is to be managed by or under the direction of the directors. So we will notice that the Corporations Act itself recognizes that the management of a company is actually by or under the direction of the directors. So if the directors choose to, they can actually be responsible for managing the company. But of course they won't, because they're often better off delegating the actual management of a company to a specialized team of managers. So that we know that, when you look at the kind of directors you look for, the kind of managers you look for, sometimes the qualities you're looking for are not one and the same. But if you look at the Corporations Act, the law is very clear that the management of a company is actually to be done by the directors or under the direction of the directors. And at the same time, Section 198A of the Corporations Act 2001 Commonwealth provides that the directors may exercise all the powers of the company. So it is the directors who exercise as a collective body all the powers of the company, except any powers that this act or the company's constitution, if any, requires the company to exercise in a general meeting. So it is possible, therefore, that the powers of the company may be limited by the Corporations Act itself, or the Constitution may provide limits to what the directors can or cannot do. So that is the statutory express basis of the legal idea that even the management of a company is actually to be done or to be made by the directors. Now, there is a very important person that some of you may have come across who said that with great power comes great responsibility. Do you remember who said that? I think it was the uncle of Peter Parker, Spider-Man. So that's important. With great power comes great responsibility. And so therefore, if power is given, so if it was the uncle of Stephen, what's his name? Peter Parker. If the uncle of Peter Parker said, with great power comes great responsibility, he would have also asked, what exactly then are the responsibilities of the directors? So let's talk about the director's duties. And these director's duties are found both in statute, meaning in the Corporations Act 2001 Commonwealth, as well as in common law. So to a great extent, there has the legal principles of the common law and the statute, Corporations Act 2001, have merged. They haven't diverged. And there are at least 4 key director's duties. One is for the directors to act in good faith, in the best interests of the company, and for a proper purpose. Directors must also avoid conflicts between the interests of the company and the director's personal interests. Directors must also exercise care and diligence, and directors must prevent the company trading while insolvent. That is, while it is unable to pay its debts as and when they fall due. And we're going to look at these more in greater detail in turn. So let's begin by talking about directors' fiduciary duty. So directors have a fiduciary duty to act in good faith in the interests of the company. It means that it is in the interest of the company and not themselves or anyone else. So on the one hand, there is the idea of the agency problem. Because the directors, remember, the directors only own a very small number of shares in a company. And therefore, and given the temptation to be greedy, the temptation to enrich oneself, there is the danger that somebody who is at the top, that there is that idea of the desire for self-interest, that they may decide to act in their own interest and not in the interests of the company or of the other shareholders. And that becomes an agency problem because when you look at it, the directors, to an extent, are actually agents of the owners. So the owners agreed to surrender their right and power to manage the company. They have designated the directors to act in their behalf. In the same way that when you look at companies now, the owners, even the majority owners in terms of the shares, don't really manage the company. So they have to delegate the power to manage to somebody else. And that creates a problem because the one who owns the company, or those who own the company, are not the ones managing the company. So that creates an agency problem. And so therefore, the law has made it clear that the directors, because they're actually acting in behalf of the shareholders and in behalf of the company as a separate legal entity, then they have to act in good faith in the interest of the company and not themselves or anyone else. Now, let me just point out at this point, because we're going to be examining it in next week, that when we talk about directors' duties involving a duty to act in good faith in the interests of the company, the law has said, at least in Australia, that the directors must act in the interests of the company. Conventionally, meaning, by tradition, the understanding is that when directors are meant to act in the interest of the company is understood to be the shareholders. Okay, so when you say that the directors must act in the interests of the company, they must act in the interests of the shareholders. That is the traditional view. But there are those who argue that given the fact that, remember, we talk about the company being a separate and legal entity, distinct and separate from the shareholders. There are those who argue, therefore, that the interests of the company are not really the interests of the shareholders. So when you think about it, what is the interest of shareholders? A lot of them are very much interested in profits. So they want to have huge dividends. And they want to have, they want to see if it's a publicly traded company, they would like to see the value of their shares going up. And so you will notice, especially in the United States and even in Australia, in relation to publicly listed companies, when a company fails to deliver on its promise to have a particular return in terms of dividends, then the stock prices go down. Now, what it means, therefore, is that sometimes what then happens is that some companies may decide, or the management team may decide, not to invest in capital-intensive projects, because to do so means that they will probably reduce profits because of the expenses that they have to put in. It can also mean that by making certain business decisions, there are business decisions that are pretty risky, and in doing so, that can mean that dividends will become less, or shareholders will not be happy. But if you look at the company as a legal entity with a personality that is separate and distinct from the shareholders, we realize that sometimes a company must take a broader view, a longer view, so that the company may decide not to give dividends to shareholders and to just reinvest any profits it has for the good of the company itself. So we need to be clear that in reality, the interests of the company are not always the interests of shareholders. And even when you say the interests of the shareholders, the idea of shareholders as a common group is really questionable, because various shareholders have various interests. Some may invest in a company in the long term. Some may invest in a company in the short term. Some people may invest in a company hoping that the company will act responsibly to society. Others don't care. So the idea, therefore, when you examine the idea of interests of shareholders, it can actually raise certain questions as to who really is the company and who really are the shareholders. But for the moment, I just wanted to think about the idea of the interest of the company, because we will talk about this later on, whether or not directors, when they undertake their duties in good faith in the interest of the company, are actually, number one, required to consider only the interests of shareholders, so that if they consider the interests of employees, or if they consider the interests of society or broader society, is that a breach of their fiduciary duties? So that's basically the question. Or if you rephrase it, the other side of the coin is to ask, is it really possible for directors to just focus on the interests of shareholders and not even to think about the interests of creditors, employees, and the broader society? So that's one aspect of it, and we're going to discuss it in greater detail later on in the next week when we talk about shareholder theory and stakeholder theory and corporate social responsibility, and the idea of the enlightened shareholder value theory, which we discuss in the next week. Now, a second duty of directors is the duty to avoid conflict of interest. So we already said that there is the idea of the agency problem, that the people necessarily are interested only in themselves. They want to promote themselves, and given the agency problem that the owners are no longer managing the company, and the managers therefore are distinct from the owners. So in other words, the managers of Kohl's are not the owners of Kohl's, as the Kohl's supermarket. What it means is that given the agency problem, and because directors wield the power of the company, it is very easy. It would have been very easy, and it has happened in the past, that directors, engaged in activities or made decisions that actually profited themselves through self-dealing. So it could be that there's a need for the company to enter into certain insurance contracts or business contracts, and then they would negotiate or deal with a company that is actually owned by a director. So that's a conflict of interest situation. So the law now says that directors have a duty to avoid a conflict of interest, so they are not to act in a conflict of interest situation. So the duty not to compete with the company, and the duty not to profit from the position of a director. And in particular, they should avoid self-dealing. So avoiding self-dealing would be, I am a director and I have another company of which I am a director, or of which I am a majority shareholder, and I want my company to enter into a contract with that particular company. That's clearly self-dealing. And not only is that type of self-dealing not allowed, but it can lead to criminal prosecution if it becomes fraudulent. Now, there is a third duty on the part of directors, and that is the duty of care. So that directors must act with the care and diligence of a reasonable director placed in the same circumstances. Now, what we need to remember is that when I talked about the topic on the corporate legal entity in week 2, I had said that one of the reasons why the idea of the corporate legal personality is a very important legal innovation is that the act of starting a business or putting up a business or running a business is very risky, because based on statistics, about 90% of startups fail within the first 5 years. So there are more businesses failing than succeeding. That should be pretty obvious, especially when you look around and you see that there was a store here, it's already shut down. And we often read about it in the press. And so therefore, business is all about taking risks. And as you would have read and you would have known, the higher the risk, the higher the return. The lower the risk, the lower the return. And it is businesses, therefore, which are in the best position to reap the greatest benefits because they undertake risk. The risk could be about entering into particular markets, coming up with a new product. It could be maybe diversifying and so on. Those are extremely risky. And so therefore what it means is that business decision making always entails risks. Now, the question then is, when a director makes risky decisions, what if that risky decision turns out badly in the sense that the company loses money? And what if, whether that decision to enter into a market or release a new product is hotly debated, and even shareholders are saying, don't do this or don't do that, but the directors do it anyway? Would it, number one, be possible for shareholders to question or impugn the decision made by the board by going to court? And can directors be held liable for the decisions that they make? And so what has happened is that there is a legal principle known as the business judgment rule, which to a great extent insulates decisions made by directors insulates them from being reviewed by judges or being second-guessed by judges, so that when the business judgment rule, which we will examine shortly, can be said to arise, then it would mean that directors cannot be held legally liable for their decisions. Now, if we apply it to the context earlier about the idea about whose interests do directors promote. Now, if directors decide, for example, that one, any activities that they do, they will just focus on the shareholders and they don't care about society and customers and so on. If they do that, would that be a breach of directors' duties? Probably not, right? Now, what if the directors say, okay, we have profits amounting to $100 million, $50 million of these, we're going to give them away to charity. Okay, so they're focusing also on the broader society, the stakeholders. Can they be held liable for that decision? If they decide, for example, that we're now divesting ourselves from this particular business because we don't want to get involved in a business that engages in casinos or does business with companies that engages in child labor and so on. And so therefore there seems to be a kind of a social side, how do you call it, social activism side to the decision of the board. And I remember, for example, Stephen Joyce, is it the CEO of Qantas, at some point saying that he was going to be a proponent of equal rights among sexes or between sexes, and he was going to take steps to invest part of the money of Qantas into that social agenda. But would that mean that there is actually a breach of the director's duties in that regard, if that is supported by the board? Because instead of focusing on the interests of shareholders, the focus now becomes broader society or a sector of society. Now, which brings us to the business judgment rule. So, according to the business judgment rule, directors will not be liable if they make the judgment in good faith for a proper purpose and do not have a material personal interest in the subject matter and inform themselves about the subject matter to the extent they reasonably believe to be appropriate and rationally believe that the judgment is in the best interests of the corporation. So, if the actions of the directors can be argued to fall within the business judgment rule, then the directors cannot be held liable for their actions. So, if directors therefore decide to give away most of their profits, the profits of the company, as a philanthropic action, and give it to charity or the poor in the Saharan desert or whatever, for as long as the business judgment rule applies, then the directors cannot be held liable. But if they did not make the judgment in good faith for a proper purpose, for example, because the directors actually have an ulterior motive, or they especially if they have a material personal interest, then in that case the business judgment rule may not apply. But for as long as it can be said that the decision is covered by the business judgment rule, then somebody who complains about the nature of the decision and seeking to make directors liable for the decisions will likely fail, because when they go to the courts will not entertain that kind of action, because the judges will respect decision-making made by the directors under the business judgment rule, especially because judges also believe that the people who are in the best position to make decisions in behalf of the company have got to be the directors themselves. And judges really are not specialists when it comes to decision-making in behalf of the company. And then there's also the duty of directors to avoid insolvent trading. So when we speak of insolvency, what it actually means is that even if a company has a lot of assets, but it is unable to pay its liabilities, then it is technically insolvent. So a company may have a lot of assets, but the assets may not really be in the form of cash, it may be in the form of machineries and buildings and goodwill and so on. But it doesn't have the ability to pay off its short-term debts. So it becomes insolvent then. And so in that case, if the company is insolvent, is unable to pay for its short-term debts, then what it essentially means is that the directors must avoid insolvent trading. It shouldn't allow the company to continue to trade because of the danger that the company will shut down and leaving a financial mess in the process with a lot of customers buying goods online and they could no longer be shipped out. It could be suppliers not being paid for what they supply and so on. Now, so there is a director's duty to avoid insolvent trading, and in a sense, the duty to avoid insolvent trading is really not a duty, but it is really a personal liability, because if directors fail to undertake their duty to avoid insolvent trading, then they can be held personally liable by whoever gets affected who suffers damage or loss as a result of the insolvent trading of the directors without the company without the directors taking the necessary steps to protect creditors. But of course, it becomes, we know it's, in a sense, it can be said to be a personal liability because directors can choose to fund the liabilities personally. They can say, okay, we will continue to trade. We will hold ourselves responsible. And this typically happens in many companies where when the company is undergoing financial distress and may be insolvent, it may mean that the shareholders themselves may decide to put up part of their assets for the purpose of making sure that the business continues to be a going concern. Now, finally, let's talk about directors' responsibilities. I always want to make these lecture podcasts short. We're running to about 45 minutes now. Now, what are directors' responsibilities? We're looking at the tasks that directors actually do, what they are responsible for. And this is provided by the Australia Institute of Company Directors. These are typically what the directors do in terms of responsibilities. They provide strategic direction to the organization, so strategic meaning long-term, for the broader interest of the organization, and deciding upon the organization's strategies and objectives in conjunction with the CEO. They also monitor the strategic direction of the organization and the attainment of its strategies and objectives in conjunction with the executive. They monitor the operational and financial position and performance of the organization directly. They drive organizational performance. They appoint or remove the CEO or other key executive appointments. And they approve the organization's budgets and business plans and so on. There are really more, you can speak of a lot of other directors' responsibilities. But what we need to highlight in this regard is that there have been studies in the 1970s, for example, that showed a huge disconnect about what was expected of directors to be doing and what they were actually doing. So, for example, you would think that given that part of the director's duties would be to ensure that they make the proper appointments in relation to the chief executive officer. And then they actually fail to do that because they end up choosing an executive officer who are their friends. So it's not about what is good for the company, but what is good for them, because based on their friendship, they can also derive certain financial benefits. And it could also mean that they don't really monitor the strategic direction of the organization or the attainment of its strategies because they're so afraid of the chief executive officer, who is very powerful, that they just whatever the chief executive officer does, they just rubber stamp it and approve it. So this is just to emphasize that directors' duties and directors' responsibilities are not meant to be apple pie and motherhood statements where they're just slogans to say this is what I do, but you don't really do it. These are things that directors must actually do, because if they don't, this can lead to potential legal liability. So after studying this topic and having gone through this lecture podcast, you should at this point be able to discuss and explain the concepts of governance and management, directors and officers' powers, duties, and responsibilities, and the business judgment rule. So with that, I thank you for listening to this lecture podcast, and see you soon. Bye.